wait for a few more people to get going. This is 5 quick and easy steps to fund your living trust. And so again, my name is Toby Mathis, and I'm going to be your host for this time, making sure that if you have a living trust that you get it started. So here's a little bit of humor to get us off to get us off on the right foot. And it's the dog and the cat saying, geez, I can't believe she left everything to that stupid parakeet. Let's see if any of you guys have lived that one. Before we get right into the living trust itself, it's important to understand that a living trust is only one component of an overall structure, and that a lot of things can still happen to us while we are alive. And so one of the first things I always address when I talk to clients is, let's say you're driving down the road and somebody's texting and they go ahead and swerve off and hit you, and they knock you into Tuesday, where you're just not in a good position to answer for yourself. Then the question is, the first responders, what are they going to be doing? How are they going to know to get a hold of somebody? And more importantly, who would they get a hold of? And then even if they could get a hold of that person, what information would they be able to share? And so your living trust and your estate plan really should be able to handle that as well right off the gate. And that is called a medical power of attorney. So before we even get into the actual funding of the trust, we have to make sure that we're addressing things that are going to occur to us while we're alive, and make sure somebody's there to answer. The answer to those things are found in your living trust, especially when Anderson Law Group does it, which is the power of attorney for healthcare, the HIPAA release, which is important, and a living will. All three work in conjunction together. The durable power of attorney appoints someone to act in your shoes and act as your advocate in the event you're not able to answer for yourself. So it's okay to have that type of document in your glove box. For you ladies, put it in your purse. It doesn't hurt to have a copy with your doctor or with the person who's going to be acting as your power of attorney, because they do not spring into effect until you're not able to answer for yourself. So they're always going to ask you first. The reason that I say put it in your glove box is because in the event that you are in an accident, the first responders will look through purses, wallets, and glove boxes to make sure that the information is available to them as to who they can talk to. Otherwise, it'd be a pretty short conversation. They may be able to figure out who somebody related to you is, but they're not going to be able to share the information. That's where the HIPAA release really comes into play. Now they have a medical release in their hands, and they're able to explain exactly what's going on. And sometimes I joke, we have that hospital where you go if you have bullet holes and if you have stab wounds or gunshot wounds, that's the hospital they may be trying to take you to. That may not be the hospital that you want to be taken to. And so if you have a preference, then it's important to let your power of attorney know that as well. So anyway, I bring that up every time I do estate planning, just because I say what's most important is making sure we have an advocate in the event that we're not able to answer for ourselves. The other one is, what if we kind of become like this lady? Yes, she looks like a crazy lady. I'm sure she's a lot of fun, but maybe she's not able to handle her own finances. And what comes into play there is the durable power of attorney for financial matters, and making sure somebody's dedicated again to act in your stead if you're not able to. And what we mean by not able to is either you're incapacitated. My father suffered from Alzheimer's, unfortunately, and for the last years of his life was not able to handle his own financial affairs. If we did not have a power of attorney in place ahead of time, it would have been a really difficult situation. And so I bring these things up for a reason, and that is because estate planning is more than just passing on. It's about what occurs during your lifetime. And more importantly, is what if you had put in place a living trust and you had neglected the funding component, and then you were incapacitated? Somebody would be able to step in and complete the funding to make sure that your trust was actually funded with the assets. And the reason that's important is because if we don't have the trust funded, if we don't have those assets transferred into trust, then the trust is merely a reciprocal agreement. I mean, it's going to be it's going to receive the assets that would have to go through probate anyway. So we want to make sure that we fund the trust. Now with Anderson, we are redundant. We have 3 redundancies built into our documents where we want to make sure that it's clear that your living trust is going to be the controlling instrument. Let's talk a little bit about estate planning and why it's important to plan. The optimist, obviously, the glass is half full. The pessimist, the glass is half empty. The estate planning attorney says, hey, the IRS took half because he didn't plan. We always want to have a plan. We want to make sure that we have the power of attorneys in place in the event there's anything we can do before somebody passes to minimize the tax. And we want to make sure that we can get off that probate RV. We don't want to have to go through the process of going through the courts. The old joke is, what do you call an attorney with an IQ over 70? And the answer is, Your Honor. You don't want to end up in a court situation because in my experience, and all I can do is speak from mine, and I've been doing this for a couple decades and dealt with well over 1,000 trusts. If you add grief, money, and attorneys and put them all together, it's going to be a very volatile situation. Sometimes all it takes is that added pressure and you're going to watch people misbehave. Probate is a guarantee if you do not do any planning at all. If you do some planning and do, for example, a will, then you will also go into probate because a will is required to be probate. And all probate is, and just think about it conceptually, is a judge transferring the asset for you. In other words, you're going to court and asking them to take it from name 1, the decedent, the person who died, and please move it over to somebody else's name. That's all you're doing. The idea behind a living trust is that you're doing that ahead of time. And so a living trust, and the key is in the word living, is effective immediately while you are alive. It operates indefinitely. In our offices, we generally use the state of the laws of Nevada because we can have 365 years. Granted, most people just want their assets to go to certain heirs in a pretty definite timeline. But for some people, they want it to go for generations, and they want the assets just to sit there and continue to go from generation to generation and benefit those folks that come after them. And it may be as simple as saying, hey, don't distribute the principal in there, but make it available to them for education, for health, for unexpected, and maybe a little bit of living expense. And therefore, if they fund it well, then those assets could go on pretty much indefinitely. But it is a true legal entity that keeps going on. The title to assets ends up going into the name of the living trust. But like most trusts, there are really 3 parties that we pay attention to. And those 3 parties are the grantor, the party that's giving the asset, the trustee, the party who holds legal title to that asset for the benefit of, you guessed it, the beneficiaries. That's the 3rd party. And in a living trust, all we're doing is taking the asset from your name and placing it into this trust, which is really a contract, and then naming successors. So you will always be the grantor of your living trust. You may be the trustee during your lifetime where you're handling those assets for the benefit of yourself because you are also the beneficiary. But then we have successors. If something happens to you, then we have a successor trustee that would step in and handle the distribution. If something happens to you and you pass and you're no longer a beneficiary, then the trust becomes irrevocable and the beneficiaries switch. And you may have instructions like give $10,000 to old Uncle Willie and then distribute the rest of the estate to my kids, but don't give it to them right away. But make sure they graduate from college first. Make sure maybe they're 25 years and then maybe give them half now and then half when they're 30. You can actually do things like that in a trust that's impossible to do with just a will. As a result, the assets will avoid probate because we do not need a judge to sign over the asset to a 3rd party. It's automatic. The living trust itself has the asset, and all we're doing is changing for whose benefit they receive. Then we have upon death or incapacity, the trust goes on and on and on. So even if you're incapacitated, it's going to be some crossover between the power of attorney and the living trust. If you don't have a power of attorney, it's possible that that living trust could come in and save you. Upon your passing, then we have actual instructions, and the trustee typically is somebody, either a professional or somebody that you trust. It could be a relative. We generally don't want the trustee to have skin in the game, meaning that if they're a beneficiary and there's 3 beneficiaries and they're one of them, it might be a little bit of a tough situation. Maybe you want to have somebody else acting as trustee, or at least acting with them. But that trustee stands into your shoes. And I get the commentary a lot of times from the client is, well, I want them to get the benefit of the asset. What happens if I put an age restriction, like they have to be 35 before they get a distribution? Well, it depends on what kind of distribution. So they may still have access to the assets. Let's say that you put assets into a trust. Let's just say it's $100,000 and it's for the benefit of your son, and your son's 18. You pass away, and you don't want your son to have an 18-year-old with $100,000. They'd be the most popular kid in their school for sure. But that $100,000 isn't going to last very long. So maybe Uncle Willie at that point, you say, hey, I want my brother, my sister, somebody to watch over those funds for the benefit of my son, and he can have the $100,000 when he's 25, so long as he's graduated from a U.S. institution, a U.S. university with a bachelor's degree. You could say that. Now, during the period of time that your son is going through school, your brother or sister, the trustee, would be watching over those funds and giving them just enough so that they can go through school. If they come up and say, hey, I want a new car, I found this new Corvette for 30 grand, the trustee can say, no. Why don't you buy a used Kia or something like that, or a Hyundai, something that's more appropriate for school, or Toyota, whatever. Don't want to promote a certain type of car, but you don't want them to have, the sports car right away. And that's what the trustee does. It's they kind of protect the beneficiary from themselves. But those are the types of instructions you can put in your living trust. You can be very, very, I don't want to say controlling, but you can definitely put some hurdles in there. You could put criteria that they get money so long as they get a 3.0 in school, and then they have to graduate from school. I've done trusts where they had very specific provisions about what they did to benefit the community, and whether they, what type of activities they engaged in, and then whether they were giving things back and tithing and things like that. You can put that into the trust and leave it for your trustee to monitor that document. This is how title to assets in the trust, how the assets are actually titled. So I'm going to use as my hypothetical tonight John Smith. And so let's say John Smith owns a piece of real estate. Instead of just being John Smith, a single person, or John Smith, you could put John and Sally Smith just as easily in this example. I'm just going to use one person because it's less words and because it's easier to understand. So John Smith, instead of it just being John Smith, now it's John Smith, trustee of the Smith Living Trust, dated November 11th, 2015, and any amendments there too. What we've just done is we've taken an asset, instead of John Smith being the owner. So if John Smith died, we'd have to go to court and ask a judge to sign over ownership. Instead of doing that, we have it already in the name of the living trust. And then we're very specific about which living trust it is, because there might be other Smith living trusts, obviously. So we make sure we include the date in it. And that's how assets are typically titled. Then you're asking yourself, okay, what kind of assets? Well, that's what we're going to get into. We're going to discuss funding your trust in 5 quick and easy steps. And really the 5 steps are the asset types. So let's jump in. The first thing we do in our documents, and if you have an Anderson Trust, you can go in and take a look. I think it's section 1.03, and that is a blanket statement where we say, by signing this document, it is my intent to transfer all assets that I own or hereinafter acquire into this trust. In other words, I want this to control my estate. This is basically the sprinkling of the magic wand dust all over your estate, saying, this is trust. I do not want to go through probate. I can't be a lot more clear than saying, I want everything to be held in trust. And then there's going to be a few exceptions. The actual provision, if you want to read it, is going to look kind of like this. Funding the trust by executing this agreement, we transfer, convey, and assign the property described in the attached schedules to our trustee. What that means is I took it from John Smith. Let's go back. John Smith individually to John Smith trustee. It's still me, but we're transferring it into the trust. We go back and we say we also transfer all of our right, title, and interest into all of our property that may legally be held in trust, and that may, by this assignment, be transferred to our trust. And then it says it includes all of our real, personal, tangible, and intangible property located in the United States, whether separate property or community property, whether acquired before, or this is really important, or after the execution of this agreement. And then it says accept the following assets. And let's go over some of those. Before we get to the exceptions, this is a very clear statement that I want everything I own to be held by this trust. And then we say, okay, now what if we transfer it into trust and there's a negative consequence? Okay, there we go. This is our exception. Let's go all the way to the very bottom one. And that's the one that we get questions on periodically. It says, hey, is this going to cause a tax? No. We want to transfer everything in. And if by transferring to the trust, there would be a loss of taxes or a result in a loss of homestead, then that is not transferred. That is excluded. And the types of things that we don't want to put in there are other trusts, things like life insurance policies where there's already an agreement. And we're going to go over life insurance policies and how they could be titled. Pension plans, profit sharing plans, retirement plans like IRAs, annuities, all those things, even Section 1244 small business stock. We want to be able to get the loss. We don't want to lose the loss in that. And so we say, here's the exceptions. If it would cause us a problem, we're not transferring it. Now, can you still transfer those things in there? Yes, but there's a different way, and that's where we get into it. So the number one way we transfer things into our trust right out the gate is using that magic wand provision. I review trusts all the time, and it's always shocking to me that there are living trusts out there that do not have a magic wand provision. I'm like, why would you not put in there a blanket assignment of all assets right out the gate if you want to use this living trust to truly avoid probate? One of the beautiful aspects of avoiding probate is removing yourself from the public record. The most clear example I can give you is right out of the paper from this last year where Robin Williams passed away. Go try to figure out what's going on with his estate. It's in a trust. Most of his assets were held in trust, both revocable and irrevocable, because he had so many assets. He was worried about taxes. So all of those things are already in place and they're not a public record. Contrast him to Philip Seymour Hoffman, who also passed away. But in his case, he used a will and everything's out there for the public to see. So that's a clear example. The other type of asset, this is step number 2, is transferring in intangible personal property. And what this includes are bank accounts, bonds, your private notes that are in your name, stock and investments accounts. So I'm going to show you how to transfer those. But before we do that, understand this. If you have real estate and it's held in an LLC, or if you have real estate that is held in a land trust and pointing to another LLC, then you do not have to transfer the real estate into the living trust. You can take your interest in that LLC, we call it stock, but membership interest in LLC is the same thing, and we can put that in the living trust. And so let's say that I have 6 pieces of rental property. I do not have to redeed those 6 pieces of rental property into my living trust if I'm already holding them in an LLC or a series of LLCs. I can just take the LLCs and put them in my living trust. And those are called intangible personal property. It's not real property and it's not tangible personal property. It's basically pieces of paper. And so we just want to make sure that no longer is it John Smith, an individual, who's owning those. We want to make sure it's John Smith, trustee of the Smith Living Trust. And so that's how we do it. We can give the bank, we can give the financial institution, whomever, a copy of a certification of trust. This is a one-page document. I'm actually showing you the document out of one of our trusts. Just change the name. And what this document is a summary of the living trust that a financial institution legally has to accept in lieu of the living trust. I don't want to hand my bank my living trust. A, it's huge. B, it's private. C, it would be really annoying to have to hoof that document down there and have somebody who I don't know start reading about where my stuff is going, what type of conditions I put on my estate. Hey, maybe I have a child who has special needs, or a child who has addiction issues. And do I want the world to know my private business? Or maybe I'm concerned, hey, I want them to go through certain type of education. I want them to go through certain classes. I want them to give a certain amount of money to charity. That's nobody's business but your own. And I certainly don't need to take that down to a bank. And so in all of our Anderson Trust documents, if you have an Anderson Living Trust, you will find a section that says privacy documents. And there's going to be a certification of trust for the trust. And there'll also be a declaration of trustee. And some institutions want to see a declaration of trustee instead of the certification. So we give you both. And it's the same thing. It's just a basic summary of the document. But you could give that document, that one-page document, to your bank and say, please retitle my account into my living trust. I could give it to my broker and say, please transfer my account into this name. And all they're going to do is type. They should not change your debit cards. It should not change your checks unless you want it to. But it'll still be John Smith. The trustee is John Smith. Now, what happens if something happens to John Smith? That account is still in the name of the Smith Living Trust. And so if there's a new trustee, they come down there and they'll either have the resignation of John Smith, they'll have a death certificate of John Smith, or they'll have a statement from the power of attorney saying John Smith is incapacitated. And then they would be able to come in. The bank, in that case, would probably want to see the physician's letter. But the trustee would be able to come in and immediately have access to those accounts. Why is this important? Ask Sonny Bono's widow what occurred in the aftermath of Sonny Bono passing. He had a love child and Cher, who loves the spotlight, come in and make contests. And that poor widow was doing her best to just try to bury her husband while all of the accounts were locked up, and had to go to court to deal with those things. We've dealt with this on a number of occasions. Last week, I was talking to a client who said, I will never want to go through what my friend went through. And her husband died. And for the better part of a year and a half, every time she needed money, she had to go back to court. You don't want that. Just title the accounts into the name of the trust, and it's done. It's automatic. That's one way. Number two way to get assets into the trust is just to simply assign it. So here's an example. I have Sample LLC. This is how simple an assignment is. I just says, basically, I'm transferring 100% of my interest into the trust. Now, instead of Joe Client being the owner, I'll go back to using Joe Smith. Let's say Joe Smith is the member. Now it's Joe Smith, trustee of the Smith Family Trust, is the member. It's still Joe Smith. When anybody needs to get approval on something, it's still Joe Smith until there is no Joe Smith. And if Joe Smith passes, guess what? Who's the member of that LLC? The living trust, and the successor trustee will be able to step in and handle the entity. Can you leave instructions, by the way, to say, hey, this is who I want to manage the LLC if something happens to me? Absolutely, you can. And so you can leave very explicit instructions saying, hey, I don't think my kids are ready to run my real estate endeavors. This is what I would like to see. And you can leave instructions to your trustee to make sure that occurs. So if something happens to you, that they don't get in way over their head on something, and they're able to make sure that the asset is not wasted. And so this is, again, number 2 is the transfer of the intangible property. So I'll go back to this. Intangible personal property. That's step number 2, is make sure it gets transferred into the name of the living trust. And the name of the living trust is your name as trustee of the living trust. And so there we go. Now let's talk about tangible personal property. This is the stuff that you can carry around, that you can kick, you can touch. The big ones are things like automobiles, your cars, the boats, things that are titled. Then there's the jewelry, things that are easy to move but are valuable. How about heirlooms and other personal effects, your furniture? The best example I can give is and I'm going to go over it in a little while, is a $3.95 item that ended up creating a probate battle. And I'll go over that one in a second. So tangible personal property, we also want to get into the living trust. Now, a car, you may say, I hate going down to the DMV on a good day. Why would I want to go down there and transfer it into the living trust? Well, here's a hint. I probably wouldn't do it. Most states have what's called a low asset probate, where you don't have to go to court. If it's less than $30,000 or less than $40,000, you can probably get away from having to actually do it. What that does is it takes the timeline and the urgency away. And then when you buy a new car, make sure you're putting it in your name as trustee of the trust. Again, just give them this certification. There we go. Just give them this document. This is how I want you to title it. John Smith, trustee of the Smith Living Trust, dated November 11th, 2015. That's it. You just give it to them and say, this is how I want to take title. And that way you don't have to go down and deal with the DMV. And frankly, I wouldn't want to deal with the DMV. So I would say on your cars, just make it something that you do. Maybe not right away. It's not like real estate where we really want to get that in there right away. In the case of tangible personal property like a car, then it may be something that we just put on the docket as being something that where it's going to occur later when we buy a new one. Jewelry. This is a big one, depending on whether you have it specifically insured or whether you've ever stated and made claims as to who owns the jewelry. I would make sure that in the event you have any jewelry that has title to it, where you've registered it, that it's probably a good idea to make sure it's registered in the name of yourself as trustee of the trust. And again, just giving them the certification to trust. Heirlooms. I cannot stress the importance of making sure that you tell individuals in your living trust where you want, how you want items divided if they have sentimental value. But more importantly, if you have heirlooms and there's any question, make sure it's listed. And one thing I'm not putting up here because we have the magic wand provision, but there's another redundancy, which is the schedule of assets. That's Schedule A if you're using an Anderson living trust. If you're using somebody else's living trust, see if they do have a Schedule A. Some do, many do, and it'll be a listing of assets, and you can list out specific items there. And then generally speaking, if it's a good estate practitioner, they will have a schedule of gifts. So Anderson Living Trust have a schedule of gifts. It's personal property gifts. And what that says is, hey, I want this item to go to this child. I want my fishing rods to go to my neighbor Ned because he probably has them anyway, right? He's probably borrowing them. How about my lawnmower? Do I want my kids to get my lawnmower? No, maybe I'll give it to the church, or I'll give it to the guy down the street who's always borrowing it too, or to the kid across the street so he can start his entrepreneurial activities early, that type of thing. How do we get personal property into our living trust? Well, here you go. Again, if you have an Anderson Living Trust, this is one of our redundancies, is we have an assignment to personal property. And it says, I do hereby transfer and convey to myself, John Smith, trustee of the Smith Family Trust or Smith Living Trust, all of my right, title, and interest to all of my tangible personal property. And then they go on to list it out. Everything from books, boats, automobiles, sporting goods, electronic equipment, music, anything, even artifacts related to my hobbies like stamp collections, everything that I own, and this is important, or hereinafter acquire, regardless of how they are acquired or the record title in which they're held. So if they're even titled someplace else, we're making it clear, hey, if this is mine, I want it to be held in my name as trustee of my trust. I don't want it to be in just my name. And what that is really doing is making the world, everybody knows at this point, that you want your living trust to control. Now, I told you I would tell you the story about the $3.95 probate dispute. This is it. It was a lawyer, estate planning lawyer, had two clients, two kids, who fought over mom's Tweety bird that was in the kitchen. Now, she'd had it in her kitchen for 30 years. This isn't a live Tweety bird. It's the plastic one, just like you're seeing on the screen. So that attorney found a identical Tweety bird and said, I'm going to put them both in a box. He bought it on eBay for $3.95. Says, I'm going to put them both in a box. I'm going to shake up that box, and you're each going to pick one. And that way you won't know which one was the one from the kitchen. And what do you think the kids did? They said, no way. There's things with sentimental values. You're going to watch people act just nuts. Those kids will probably light money on fire so that somebody can get this little Tweety bird. So make sure that your Tweety bird that you're listing out, who gets the Tweety bird, it may not seem important to you, but again, you're just going to have to trust me on this one, that when you put, again, emotion and grief and lawyers together, it's combustible. It's going to explode. And so if you put your kids in a position where they get to go deal with some lawyers and they're upset and they're being told things by a third party, here's what you're allowed to do and here's what you can't do, don't expect them to be impervious to the pain of it all and to not act out. That's when they start to act out. And I see reasonable people act irrationally all the time when they're under those circumstances. That's why we have so many probate stories of things going awry and people destroying families over this stuff. So make sure it doesn't happen to you. The fourth step is transferring in real property. And this is making sure that if you have real estate and it's deeded in your name, so this is generally speaking going to be your personal home. But if you have real estate and it is your name, you're going to want to get it into the living trust. Now, there is a difference between warranty deeds and quitclaim deeds. And that's going to have to do with whether or not the title company will insure title. A lot of times you see quitclaims when somebody's putting something in an LLC or putting it in a land trust. You may have title issues as a result, and they think, well, I'll just take it back out if I ever have an issue. I'm not worried about title. But if it's your house and you're putting it in your living trust, then you don't want them to have to probate it because you used the wrong deed. Make sure that you're using a warranty deed and that you're reserving things like your homestead exclusion. Make sure that you're, warranting title. A lot of folks think that due on sale clauses, by the way, are triggered by transferring to their living trust. But since 1982, we've had the Garn-St. Germain Act that says if it's a grantor trust, which a living trust is, and you transfer it into the living trust, a piece of real estate, that the bank cannot call it due if it's your primary residence. The other big one is if you have property in multiple states, you will be probating in every state that there is real property unless you transfer it into the trust or you have it in another entity. And the example I used about 10 minutes ago was if you have your rental real estate, for example, in an LLC, you don't have to transfer ownership from your name directly into the living trust anymore because it's already held in the LLC. What you would do is you'd transfer your ownership in the LLC into the living trust. And so again, instead of John Smith being the sole member of the such and such LLC, ABC LLC, it would be John Smith, trustee of the Smith Family Trust, being the sole member. And now we don't have to worry about transferring that piece of real estate. So let's just we're really going to be limited here on what type of real estate gets transferred in. More than likely, it's going to be personal residences, because real estate that is rental real estate, you'd be crazy to have in your name. You want to make sure that gets out of your name quickly, just because of the liability that comes along with it. So here's an example of a warranty deed. And that's just John Smith, the grantor, does hereby convey to John Smith, trustee of the Smith Living Trust, dated November 11th, 2015, and any amendments thereto, the grantee, the following property. And then you give the little property description. It's quite literally a 2-page document. Quite often there's a tax document that has to be filed along with it, but there should not be any cost to this other than the recording fees for the transfer. It's not a taxable event. There shouldn't be due on sales. It should be something that manages to go straight on into the living trust without having any problems. And this is where we get into our first webinar offer. And the first webinar offer is deed preparation. If you have a living trust and your personal residence has not been transferred into it, or you've been told, I will lose my homestead, there's a way to keep it and still place it into the trust. Anderson Business Advisors will do that for $250 per property. So your personal residence, we'll get it transferred in. The only thing extra you would pay is the county fee. So for example, if your county charges $10 to record a deed, this would be $250 plus that $10. If they charge $25 or $50, whatever it is, they're usually not very much. Then it would be whatever that is. But we will prepare your deed and transfer the property into your living trust to make sure that your trust is properly funded. We'll do that for $250 per property. So you can certainly contact us and take advantage, or I'm sure there'll be a link somewhere where you can get that done. Guys, do not think, oh, I'll just go down and do it next week. If you haven't done it for 6 months or a year, just have somebody do it. Otherwise, you just wasted your money. You don't want to have that house have to go through probate. The next step, the 5th step, is making sure that your retirement plans and insurance are properly arranged with the living trust. Now, a lot of people think, all right, I have an IRA. I already have somebody designated. It's not a big deal. Well, there was a Supreme Court decision that came down this last year that says in an inherited IRA, creditors can go ahead and access it. And I'm not talking about your creditors. I'm talking about, what if you leave it for your kids? Their creditors could, because they said, hey, it's not a qualified retirement plan for the child. It is an inherited it's an inherited IRA. So the creditors can step on in and grab it. Not a good situation. So the remedy, or the way around that, to make sure that doesn't happen, is to name your living trust as a contingent beneficiary. A lot of spouses will just name each other, but then if something happens, we don't want our kids to just get a big lump sum of cash, especially if they're young. We could still put the same provisions in for the living trust to make sure that the trustee has a certain degree of control over how that is rolled over. And more importantly, if there's a child that has creditors, and the best example I can give you is there was a couple who had a child who had special needs, and the child was functioning. When the parents passed away, the state in which the child resided, in this case it was Pennsylvania, came back for 18 years of assistance and said, fantastic, we're so glad that you inherited this money. We're going to go ahead and take it now because we've been helping you along the way. The state had been providing benefits, and they were entitled to come back and get it. So you want to make sure that the living trust is controlling, because in a living trust, we actually have special needs provisions. But there's also credit shelter provisions that say, hey, if there's a creditor of a beneficiary that's going to try to step in and take the inheritance, don't give it to them. It's that simple. It's not their money. They may be a beneficiary, but that's it. It doesn't mean they get to go in and raid the trust. The trust can still have provisions that say, don't give it to them. Don't give it to them. Same thing with people like ex-wives, ex-spouses, ex-husbands, to be politically correct. If you want to make sure that the monies that you are leaving, or the properties you're leaving for your children, do not end up in somebody else's hands, you make sure it runs through the trust. Life insurance, again, a lot of people just will name their kids as life insurance beneficiaries. And if those children are not ready to handle that money, then you just did them a huge disservice. If somebody's not capable of handling funds, then they could be in a real bad situation. And then we have qualified retirement plans, your pension plans, your 401ks. Same situation. The living trust is not the owner. The owner is the individual who sets them up, and then it has beneficiaries. And so if I have a pension plan, the profit sharing plan sponsored by my business, and I am the participant, I can name that my living trust will be my contingent beneficiary after I die, maybe after myself and my spouse. Then it'll go into the trust, and the terms of the trust will help control. And we put in what are called conduit provisions. So all you financial planners out there that are going, hey, wait a second, that could be taxable. Yeah, we put in conduit provisions for the trustees to make sure that we can avoid any negative tax consequences, and they could roll it into another IRA or another 401k, or even continue on with the plan. And so we want to make sure that those that we're giving our trustee the ability to handle those for the benefit of our beneficiaries without just giving the cash to the beneficiaries. That could be, again, an extremely negative situation. I just had this with a financial planner before. They were trying to transfer an IRA into a living trust. And I said, stop doing that. It's an individual retirement account. You leave it in the client's name. You make the beneficiaries, the contingent beneficiary, be the living trust. Then you don't have to worry about anything. You don't have to worry about creditors coming in there and snagging it. And we have a lot more flexibility. So that's important. So that's our fifth step. So we already went through, I'll go all the way back to the beginning. We had magic wand provisions, which is, hey, I am hereby stating everything that I own is transferred into this trust. We have the intangible personal property. We're transferring bank accounts, stock accounts, even notes, even membership interest in our LLC, everything in. We're making sure it goes in. Tangible personal property, our vehicles, our jewelry, our family heirlooms, all of those things. We're making sure that it's covered in there. So that, by the way, on this one, we can put in there, if you contest. So if you decide you're going to be a litigious kid, you're out. You're out. You get nothing. We can put that. This is a private document. This is a contract. If they violate it, there's still remedies. So we want to make sure our tangible personal property is in there, and our real property. Make sure that our real estate that is in our name. Remember, if it's in the name of an LLC or even a corporation, you do not have to transfer it into the trust. The real estate, the shares or the membership interest in the entity, in the LLC or the corporation, should be transferred into the trust, and that's the same as transferring the property in. And then we get into the retirement plans and insurance. That's step number 5. Make sure that you go in and make the beneficiary designations so that the living trust is the contingent beneficiary. And then if we miss it all, if we completely whiff and we make a complete mistake and we don't fund our trust, we still have a pour over will. That's our catcher. It's going to keep the ball from hitting the backdrop or backstop. This is going to make sure that anything that we have, we name our living trust as the sole beneficiary of our estate. So even if you manage to not transfer anything into the living trust and everything is out in your name,